Good morning and welcome to today's Ask a Pro webinar. We're very excited about today's topic of probate recovery, as we're aware that while most creditors encounter deceased signers, many don't have probate recovery at the top of their list of strategies. We think that being prepared in these situations can benefit you greatly. The probate process can be very sensitive to navigate for obvious reasons. We know that your brand image is important to you, and we want you to leave today's session knowing that there are options available to allow you to confidently handle these matters while keeping the relationship with your customers and their families front of mind. My name is Dave Tomer, and I'll be the moderator for today. I'm the National Director of Collections here at Weltman, and I've worked for over 30 years in the financial services industry, have managed the collections operations here at the firm since 2003. I'm also a current member of the National Creditors Bar Association. Before we get started, I'd like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions to the question button on the control panel. Audience questions will be addressed during the presentation where applicable. This webinar is being recorded. At the conclusion of today's session, a link to the recording and a copy of the slides will be sent to all attendees. Lastly, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. Now, let's learn a bit more about the panelists. We'll start off first with Shareholder Scott Weltman.
Hi, good morning, everybody. I'm Scott Weltman, and I'm an attorney and a shareholder here with Weltman, Weinberg & Reese. I am just finishing my 30th year with the firm. My main practice areas are commercial and consumer collections. I also, for a big bulk of my career, going back probably 25 plus years ago, was very actively involved in our probate recovery group. I was one of the founders of the group with a number of other people, and worked extensively in that area up until the time I became managing shareholder about 8 years ago. And I'm happy to rejoin the group and work very closely with Michelle Moore and her team of probate specialists.
Thank you, Scott. Our next panelist is attorney Stefanie Collier. Stefanie, why don't you share a little about yourself?
Hi, good morning, everyone. I'm Stefanie Collier. I'm an attorney here at Weltman. I've been with the firm for around 6 years now. I mainly practice in external compliance reviews for clients, along with litigation and defense and consumer collections. Excited to be here.
Great, thanks, Stefanie. And our final panelist is the manager of our probate group, Michelle Moore. Welcome, Michelle.
Good morning, everyone. Michelle Moore. I've been with the probate department. This year was 26 years with the firm. I started in probate. I was a legal assistant, and then I became the clerical specialist supervisor, then the estate specialist supervisor, and now I manage the group. So I hope you guys all enjoy the webinar today.
Great, thanks, Michelle. I want to thank our panelists for their participation. And without further ado, let's get into the first question. So Scott, I'm gonna direct this one to you. What happens if a creditor never finds out that a customer is deceased?
Well, that's probably the most important issue in dealing with probate, is finding out that someone's deceased and then starting a process. The question, of course, is what if you don't find out that the customer is deceased? As we're going to get into through the course of the hour, the probate process is very time sensitive. If you never find out that your customer is deceased and you're unsecured, ultimately you're going to be out. You won't have a path to recovery. If you're a secured creditor, you'll never lose your rights against your collateral, and we'll talk a little bit more later on about what you can do with respect to your collateral. There are ways to find out that a customer is deceased. Often it's information that's given to you by the family members. And maybe you get return mail, maybe somebody calls in. There are services where you can scrub your portfolio, so it is important to find out because it's such a time-sensitive process. And the only other thing I'll touch on that I'll preview for later in our conversation is that if you do have a revolving type of debt obligation and a customer is deceased, there are remedies for people who continue to use that line after your customer is deceased. And again, we'll touch base on that later. But what I can tell you is that it is critical to have to get the information as soon as you can that your customer is deceased, if possible.
So thanks. You mentioned a couple of ways to get at the information. What do you think is the best way to identify deceased customers in a portfolio?
Well, unfortunately, Like I said, a lot of the information, you're reliant upon others to give you that information. So everyone could think about their daily life, and if unfortunately you've had a relative pass away, you get a bill in the mail and you call somebody, you send an email, maybe mail gets returned to you because the person lived alone and you know, comes back deceased. The best way, if you have the scale, is to engage in some of the data death notification software and processes that take place. So you'll get notified, similar to how people are notified in bankruptcy if they sign up for those services. Those services do exist on the probate side, and yeah, like I said, I would say what you need to really do is keep an eye, of course, on your portfolio, on your debt. If you start going delinquent, you're starting to make phone calls, that's one way you're going to find out. But I mean, ultimately, you're at the mercy of the third parties that you're dealing with. The software programs that exist, the search programs, that's the best way if in fact you have access to that.
Okay, so first choice would be a data scrub, which is probably the most proactive, and then secondarily just making sure processes within your call centers and so forth call out those decedents as soon as they're made aware.
That's correct, and obviously on the inbound mail side, make sure that gets coded properly and gets to the right people.
Great. Stefanie, here's one for you. How time sensitive is the probate process, and is it important to proactively identify decedents?
She's on
Stefanie,
mute.
you may be on mute.
Stephanie's on mute.
Okay, I think
Yes,
you're muted.
you may be on.
Oh my goodness, sorry.
There you go.
Not enough coffee today. So I'll start over, I apologize. So the clock starts ticking from the date that your consumer passes away. So probate is extremely time sensitive. Think of it like bankruptcy. You've got a certain time limit to file your claim or you're forever barred. So as soon as you know that your consumer is deceased, you're going to make sure whichever jurisdiction that consumer passed away in and an estate is filed, that you are filing within those timelines. So just to give you some examples, in Ohio, you've got the earlier of 6 months from the date of death or 30 days from when the fiduciary delivers you notice. In Indiana, it's a similar timeline. It's 9 months from the date of death or 3 months from publication of notice of the estate. So you need to be very proactive with this. And just something else to mention along the lines, because I see this a lot in my practice, as soon as you file your claim, your job's not over with. You need to keep following up, making sure that the representative of the estate or the fiduciary is going to pay that claim because it might get rejected. And then you're going to need to follow the local rules and work with your attorney to make sure that you're following the process for making sure that claim eventually gets paid.
Great, thanks, Stefanie. So kind of reeling back to the point where we become aware of a decedent. Once we're aware, Michelle, what steps should be taken to protect our interests?
Yes, we should. Once you find out that someone passes away, you need to search for an estate in the county that they resided in. If an estate is open, then you want to file a claim to protect your interest within that time frame for that specific state. Each court has their own rules for filing a claim. Some require a fee to file a claim, some require an estatement to accompany the claim, or some have a special form for that specific county that they want used. Each state has their own rules as to who to send the claim to and the deadline to file a claim.
Thanks. And in that estate search, you mentioned the location and the county. What specific location or county should be searched?
You would go by their mailing address with the zip code, whichever county that falls under. There's about 3,100 probate courts out there. So once you find out someone passes away and the file is placed with Weltman, then We can search by we search by phone to some of the courts. Some courts are website searches. Some courts we have to hire a vendor in that certain area in order to find out if an estate's filed, because the courts there are not always friendly to creditors, so they give us a little bit of a workaround in order to find out if there's an estate. And also the courts have websites we can, and a mail search, I apologize. We have also, you can mail to the court to find out. And usually when we receive a file, if it's within the 30 days from the date of passing, we want to make sure that we wait at least 30 days. We don't like to start contacting the families or anything. We give a little bit of a grace period. So probably about 30 to 60 days after the date of passing, we'll start searching. Our system is designed that once a file is placed with us, it reads the zip code, and then we have a probate view that puts all that information in there, how to search for the estate, where to search for it, how to file the claim. All that information is added to our system.
And the claim process, is it the same in every state?
No, it's different. All states have different time frames to file a claim, has different ways to file the claim. The counties then have their own special rules and ways to also file. And it's all time sensitive, like Stefanie mentioned before.
Great, thanks. Stefanie, back to you. For situations where a creditor is secured by collateral, such as a vehicle, should they be concerned and looking to locate an estate and file a claim, or looking for the vehicle? What do you recommend?
Yeah, absolutely. You should still be concerned with trying to find an estate and filing a claim, and here's why. Because once you get that vehicle back and you've secured your collateral and sell it, there might be a deficiency balance. So if you haven't filed your claim, then you're not going to be able to collect on that deficiency if you miss the timeline to file your claim. And you can always go back and amend your claim. So if you file a claim, as soon as you find out your decedent's passed away and estate's been opened, file a claim for your full balance. You can still take back your collateral, sell your collateral, and then amend your claim for the deficient amount. That way you can make sure that you are going to get paid. And then make sure, along with the lines of taking back collateral, that you're also still following the repossession rules of the state that you're in. Every state has different repossession rights that they allot to the consumer. So you want to make sure that you're still giving a notice of sale and a deficiency letter after sale. And I usually advise our clients to send those letters to either the estate representative, the estate attorney as well. So again, make sure you always file your claim. You can always go back and amend it, and additionally work with the estate attorney or the estate representative to get your claim paid then.
And you would recommend that regardless if the loan continues to be paid current by somebody other than the decedent over the course of time?
I'm sorry, could you repeat that, Dave? You kind of broke up there.
Yeah, in scenarios where a loan continues to be paid by maybe another family member, right, and collateral is outstanding, would you recommend filing a claim regardless of that loan being current?
Oh, absolutely, because the family member has no obligation to pay the loan. They're not on the loan. So you want to make sure you're still filing your claim. And then that gives you another opportunity to work with that family member and the estate attorney. If the family member wants to obtain a loan and buy you out and then take possession of the vehicle to transfer it, that's absolutely great. That way you're at least working towards getting paid and being made whole.
Great, and I had an audience question real quick come in. Can we repo a vehicle even if an estate has been established? And follow up to that, do we have to accept less than a payoff if we permit them to sell it? Scott?
It's interesting. I just spoke to a client yesterday on the exact situation that came up in the question, which was there's an estate, the loan paid, what can I do about it was a tractor, but still, a vehicle. And, the practical advice was find out what their plan is. Are they talking to you? And the conversation we had was if they think they're going to try to sell it, and as long as they're paying you, there's nothing wrong with that. But ultimately, if they're not gonna get it paid, you absolutely have a right to repossess your collateral while the estate is pending. You have your rights against your collateral, and you should be able to exercise those. The nice thing about having an estate, and Michelle deals with this all the time, is when you get a representative, they may be able to arrange for you to come pick up your collateral. You might be able to do a voluntary recall, but that being said, if they're not cooperative, you can repossess your collateral, you can file a replevin, you can do any of those items. You have your rights against your collateral. And I'm sorry, what was the second question, Dave?
Yeah, just whether you're compelled to accept less than the value of the collateral, I guess, or settle in the event of a claim in an estate.
No, you're not compelled to accept less. That becomes a business decision, whether you own what's the value of your collateral. But they can't lowball you. If you're going to do better by getting your collateral back and selling it on your own, you absolutely have the right to do that. Now, I will qualify that. I'm not an expert in 50 law states, so that's a conceptual point of view. I'm not saying there may not be a state law out there somewhere along the way that has a different answer, but that really would be a state-by-state thing. But I'm not personally familiar with anything that would make you take less than you could get if you were to sell it.
Great. And then,
just to add to that, Dave,
I'm sorry.
if the selling costs and the repo costs, exceed the amount that the vehicle's worth, it might be worth, again, just accepting less than full balance. Again, that's a business decision, and I think you have to look at a lot of facts there.
Yep.
But you're not compelled to accept less than full.
Great, good point. Shifting gears, but kind of on sticking in the collateralized space. What about mortgage holders? Are they protected by the mortgage on the real estate, or could there be exposure there? Scott?
So similar analysis. Your mortgage is on your real estate is your collateral. In a mortgage loan, you have a note, that's your debt, and you have your collateral. And you always retain your rights against your collateral. You are protected by that. Now, what I can tell you is that you'll have to go through an analysis. Is the loan being paid? What's the family members? What's their intention with respect to the real estate? How much time do you want to give them to sell the property voluntarily? How much equity is there in the property? There are many instances where the estate is going to take an affirmative step to sell the real estate, and they need to bring an action in the probate court to do so, to get permission, if you will. Very often, you as a secured lender on real estate will get named in an action like that. It's critically important that you get that to somebody to file a response to file into that lawsuit to have your balance, because once the probate court takes jurisdiction over the real estate by that lawsuit, you won't be able to separately foreclose and need to assert your interest. So you can make that decision as far as foreclosure. And of course, there are some notes that death isn't a default. I won't get too deep into default, declaring default, but there are steps you have to follow. But if the loan is delinquent, you have every right to foreclose it, as long as there hasn't been an action brought in the probate court. All I would, and to the earlier point, you would separately file a claim in the estate for your full debt, and one day if there was a foreclosure sale and you have a deficiency, you go and amend it down. But you retain your rights on the debt against the estate and your rights on the collateral with your mortgage against the real estate.
Okay, great. Michelle, I had one for you. In the event I'm going to say you don't find an estate, in the event that a family doesn't probate the decedent, is there an opportunity to file a claim anyway?
If they don't file an estate, if there is collateral and you have security, a creditor can force open an estate if it's cost effective. And then they can file their claim once they've been appointed as administrator of the estate.
So we find out somebody's deceased, but we are not able to locate an estate because one hasn't been opened. A creditor can compel opening an estate?
Yes.
Okay.
There's a lot of costs involved in that. So again, it depends on what the collateral is, if it's cost effective for them to pursue that. We do have a forwarding group that for all 50 states that we can send to an attorney if it happens to not be in one of our footprint states. So we do have a network of attorneys that we utilize for those types of situations.
Okay. Thanks for that. Next question, question 8. Are creditors exposed to charges on lines of credit that are made after a consumer passes? And if so, what can be done to recover? So kind of after date of death charges, if you will.
Okay, yes, we have a program actually with for files that do have charges made after the date of passing, and it also runs simultaneously with our date of death balance. So we're still searching for estates while also trying to find out who made the charges after the date of passing. If there is an estate found, we file a claim for the date of death amount, and then we make the attorney or the representative for that estate aware of the charges that were made after the date of death, and then we send them the statement so then they can review that with the family to find out who made those charges. A lot of times the charges are made by a surviving spouse or someone that had access to the account or actually was an authorized user that had their name on the card, and they use it thinking that they can use it. They don't use it because, oh, I'm just going to do all these fraudulent charges and increase the balance. They do it because they're charging because they think that they can. And then once they find out they weren't supposed to, then more than likely they will pay off that amount that they charged. And again, if there's an estate, we can then file a claim on the date of death portion of that. If there is no estate filed and the person that made the charges after the date of passing and they are choosing not to pay the amount that they did charge, you can file suit against that person that used the card.
Great, thank you. Good information. Scott, how does a creditor identify and qualify estate assets once an estate's been located?
So this question has a lot of parts to it. Let me step back for a second and tell you this. The probate process in probate courts deals with probate assets only. So, you know, when people hold their assets, they hold them lots of different ways. There are a lot of assets that are non-probate assets. Somebody could be a billionaire and never have an estate in probate court. We could file a claim. Examples of those types of properties are types of assets. Life insurance proceeds, that's a very common one. Most life insurance has a beneficiary. They could have a $1 million life insurance policy and it will pass all to the beneficiary without going through probate. Joint and survivorship property, payable on death property, often property held in trust. And so the critical issue when we're dealing with an estate is what are the probate assets that are available to satisfy creditor claims. And so the question is, how do you identify and qualify estate assets? When an estate is open, if you think about the fiduciary, their job is to gather all the probate assets and gather all the debts and then distribute the assets according to the law and according to the will. And so one way to identify what assets are in the estate is what gets filed in the probate court. Most probates will have an inventory filed by the fiduciary that will list all the assets that are subject to probate. That's the easiest way to know what's in an estate. What do they file for what's in the estate? Now, they may miss something. You may know about something. You have to have knowledge. The easiest asset to trace, if you're an outsider, if you will, is real estate. Right? Real estate is a deeded property that's public record. You can always go to the public record and pull a deed to see whether and how that property sells. Again, if Scott and Melanie Weltman are married and we hold a property joint in survivorship, that's never going to go through an estate. If it's just Scott Weltman in my own name, that would be a probate asset. That's a good example. But we often get asked questions by clients, boy, this person had a lot of money, how come there's no money in the estate? And it's for all the reasons I said, because all their assets are held outside of it being a probate type asset. And so often you're a creditor, let's say you had a commercial debt and someone filled out a personal financial statement. You could be able to look at those assets or bank accounts. They wouldn't necessarily go to an estate, but it's worthy to ask the estate attorney or the fiduciary attendant, what about the this particular item. Sometimes card titles are people own those, and you can get records of who's on the title. But to identify the asset, that's what's filed. If you think something's missing, then you can do some of your own research, but you've got to be careful.
So, just kind of a follow-up on if we locate in an estate, file a claim, we can expect to be paid in full, right?
Not necessarily.
Okay.
So will you be paid the amount of your claim? The probate process is going to take all the assets and all the debts, and there's an order of priority. And so many estates, there's plenty of money to pay all the creditors, and you will get paid in full. To be very honest with you, there's many times somebody dies and you don't even know about an estate you're paid in full because there's enough money that they don't even bother with the claim process. Some people don't want to bother the claim process, but in the state where a claim is filed, the first thing that's going to happen is the estate attorney or person running the estate is not going to do anything until the claim period's over. Right, so let's use Ohio. That's an easy one for me. It's pretty clear cut. It's 6 months from the date of death. No matter when you file your claim within that 6 months, it's unreasonable to expect any payment until the 6 months expires, because as an estate, how do you know what might show up? How do you know that the person didn't have $1 million guaranteed loan out there that was defaulted on 3 years ago? You'd like to think you know your decedent, but maybe you don't. And so you wait for that period to end. When that period is up, when the claims period's up, what the estate is going to do is there's a priority statute in every state on who gets paid before the next person gets paid. And there is a lot of priority debts ahead of unsecured creditors. To be honest with you, the highest priority is often going to be the secured creditor, but we covered that already. And so expenses of administration are a priority claim. They get paid before unsecured creditors. Funeral expenses are often a priority claim. The attorneys have to get paid, of course. We always want to get paid. So we write the laws, we make sure we get paid. And there's a number of other categories. They all vary by state on who gets paid. And if you think about it, they go in order. You go to category 1. Once they're paid, you go to category 2. Once they're paid, you go to category 3. Ultimately, when you get through all those categories, but before the heirs get paid, is the unsecured creditor on the claims. And if you can get through that, every category and everyone gets paid 100 cents on the dollar, great. Often, not often, but sometimes you'll get to that unsecured category, and now you have $50,000 in money left in the estate and $100,000 in debt. If that's the case, you're going to get 50 cents on the dollar. So you are not necessarily guaranteed to get paid 100%. What we often find is you file a claim and they'll call and they want to settle, right? Oh, will you take 50 cents on the dollar? Will you take 75 cents on the dollar? It's critically important. If you file claims on your own, and it's not as long as you know the right court and the right form and who to mail it to. If you get that call and get offered, the first question is why? Why are you offering me that amount of money? Well, the estate's insolvent. Insolvent doesn't mean zero. It means not enough to pay everyone 100% in full. You have every right to ask for a schedule of all the other claims and all the assets to know why they're offering you that money. There may be reasons to take it. I've had matters over the years where I know where there was an asset. It was a farmland, and it was going to take a long time to sell it, and the family wanted to fund it. They'd rather pay you 80 cents on the dollar now, and then if you're willing to take it now, there's a time value of money. And so as long as with eyes wide open you agree to take less, you certainly can. But nobody can ever force you to take more than you're entitled to. It's just you may have to wait a long time.
Great. So a lot of questions coming in from the audience. I'm gonna roll back to something related to a mortgage holder. And if the decedent is a sole owner, should a creditor accelerate the loan at the time of receiving the death certificate? Would that be recommended action?
Well, so a couple of things on that. First of all, make sure that your loan documentation allows you to declare a default upon death. So that's always read the loan documents. Many do have death as an event of default, but some don't. I've read both. And if you don't have death as an event of default, you may not accelerate that loan, at least until it goes delinquent. So that's the first thing. If you do have that right to do that, then it becomes an issue of, if I'm the sole owner and yet, my children are now living in the house and they say, this is what we want to refinance it. We want to assume the loan. You have all those business decisions to make in there. Or we're going to sell it, and let's say they give you proof that the property is listed for sale by the estate. That's your decision, and you sort of have to gauge. You have your own regulatory concerns, but just because they're the sole owner doesn't mean that you should declare default. But you should know your legal rights and options and make decisions off of that.
Thanks. Similar question for you, Stefanie, back to collateral, auto collateral or vehicle type collateral. Same scenario. If the decedent is the sole owner of the collateral, do you have to wait to open an estate before you can sell it, or is there any limitation on when you can sell a piece of collateral in possession related to the estate?
No, there's not. Again, similar to what Scott said, make sure if the account is current, that death is a default provision in your loan docs. So make sure you've read those over. But yeah, go and pick up the vehicle, sell the vehicle. Again, make sure you're giving notice and you know which state you're in, so that you're giving the correct repossession notice prior to selling that sale. There might also be a right to cure. You could be in a right to cure jurisdiction. So if that's the case, I always just recommend sending that beforehand, before you've picked up the vehicle. But there's no requirement that a probate estate be open prior to picking up the vehicle and selling it. Again, you just want to make sure that you filed your claim within the estate. That way you're protecting that deficiency balance should there be a deficiency after sale.
Great, thanks. Scott, back to you. More of a commercial related question. Are there any unique challenges for fixture filing UCC liens?
A commercial debt when it comes to probate is treated just the same. There are no unique issues. If you have a security agreement and you have UCCs, then you'll be governed by the terms of your security agreement, and that's irrespective of whether somebody's passed away or whether they're alive. So there are challenges in commercial debt. For example, if you have a guarantor and the loan's current, again, you got to look at your loan documents. Sometimes the loan document says that the death of a guarantor is an event of default. You have to decide whether you're going to declare that. And really, what we haven't gotten into, and this is a little bit of a tangent from the question, is what do you do when you have a commercial loan and a guarantor passes away, yet the loan is current, the business is paying as agreed? You actually do have to file what's called a contingent claim with the estate. You have to say, one day this person may owe money, and that's probably a whole separate webinar when it comes to dealing with guarantors on deceased commercial debt. But rolling back to the question, you will treat that commercial debt and that collateral no different than you would the way we talked about the residential mortgage or the vehicle.
Great, thanks. And then Michelle, one back to you on the after date of death. How about a scenario where the ADOD charge or after date of death charge is actually for funeral expenses?
Good question. In that case, we do include that with our claim if there's funeral charges, since that is a priority debt, and we make the attorney aware of that. If there's no attorney, we make the representative aware, because they should not have used the card after the date of passing to pay for their funeral. So yes, we have a little bit of leverage on that. You're more of attorney, it's more of a priority claim at that point versus just a regular unsecured creditor because it's for a funeral expense.
Okay, and I'm sorry.
Can I add to that? And Michelle's spot on. The legal reality is the person who used the card is personally responsible for those charges. Often, in the practical sense, if they pay it, they'll just get reimbursed from the estate. And so instead of the money flowing from the estate to the user of the card to the creditor, it's just as easy for the estate to pay it. And that's why we would both notify the person who used the card they're responsible, but also notify the estate, because if everyone's getting along together, the money's going to come from the same place.
Great, thanks. And one more question. I think we touched a little bit on the prioritization of claims, but is that priority generally the same state to state, or does it vary?
I would say conceptually it's similar, but it is very state specific, and it's the order and the amount all vary by state. And you just, some, they have family allowances, and those vary by state. And where funeral bills get paid vis-a-vis, nursing home bill, it varies by state. You must know the state statute, and we have we've had 25 years of database, and we constantly update it because those laws, once you know it, it changes. And so you got to stay on top of it. No, every state is very, very specific.
Great, got it. Thank you. So onto our question 11. Rejections occur. Scott, can you explain a little bit about a rejection and what a creditor can do when they receive one?
Sure. Thank you. It's a great question, and it's the true rejection analysis is more time than we have left today, but I'll give you the short version. First of all, when you file a claim in an estate, you present a claim. Most states, there is no process where your claim is accepted. Right? A claim is a claim, and it's presented, and it's deemed valid, if you will, just because you presented it. However, the estate has an option to reject the claim. All my clients are my friends, and all my clients' debts are valid as far as I'm concerned, and so I don't ever see any good reason to reject the claim. But that's but they exist. I'll give you an example. Let's say you had a very similar common name, Robert Smith, and Robert Smith passes away, and you file a claim, and it turns out you filed it into the wrong estate. It's the wrong Robert Smith. All right, it's an honest mistake. You got the wrong Robert Smith. In my world, I would have picked up the phone and called somebody and said, "Hey, we got your claim. I don't think it's the right Robert Smith," and you work it through. But ultimately, maybe they can't work it through. That's a valid reason to reject the claim. It's not this person's debt. All right, but generally, what I find is an estate often tries to reject the claim to get you to go away. They hope that you will not do what I'm going to tell you need to do, which is to pursue that rejected claim. The statute of limitations, the time frame to act on a rejected claim, is shorter most of the time than the period that you had to file the claim. So again, I use Ohio. It's just a good example, but there's other states. If we get a rejection in Ohio, you have 2 months from that date you receive that rejection to file a lawsuit against the state to enforce that debt. There's some states we have to attend a hearing. Every state is different, but often you have to bring some affirmative legal action. And so, what can the creditor do? What I can tell you this: if you do nothing, you'll be out. Period. You won't get paid. I'm dealing with a couple of rejections right now where the state attorney decided they're going to reject every claim. Why? Because they're going to gamble that some people won't do anything, and that's more money they'll preserve for the heirs, which is, to me, unethical and it's wrong, but that's the approach that they take. And so, what I urge everyone to do, if you do it on your own, the first question is to call and say, "Why did you reject my claim?" Maybe they'll engage you, maybe they won't engage you in dialogue. Maybe they say, "We didn't know anything about you, can you send us some statements?" I will tell you this: if you try to work that out on your own, outside the legal process, you have every right to do so. But if you don't get a document that says they're withdrawing the rejection, they can tell you whatever they want on the phone. You will be out. You will be out, and they can be as nice as possible. And I don't want to say that anyone is trying to be dishonest in the process, but if they string you along, and all of a sudden the deadline ends, you're out. The only thing to do legally is to bring a legal action, and most likely you're going to need an attorney to do so. And if you file that lawsuit, you will win that lawsuit 99 times out of 100 because your debt is a very valid debt. You've got credit card statements, you've got a loan, you've got a loan history. Your debt's a good debt. It's not a forgery. And so you'll win that, especially because the state people, they're not in the business of litigating. We're in the business of litigating, they're estate attorneys. They're estate attorneys of relatively modest sized estates. They're estate attorneys for multi-million-dollar estates. They would just pay, every debt would get paid. And so what you need to do is you need to file a lawsuit and or whatever the state requires. It's a fairly simple lawsuit. It's a, you know, one day you might have to go to trial, but the thing about the trial, you're the expert, right? You have got all the evidence. They know nothing. They know nothing on the backside. And so many times when we file a lawsuit and a rejected claim, we get those resolved quickly, either with a quick payment or we get them resolved with a we'll accept your claim. I'll just give you a quick war story of one that I had the other day. There was a claim that was rejected. I filed a lawsuit. I called the attorney and said, why did you reject the claim? Well, we were just not sure what's going on. I said, great. Well, I need to take your client's deposition then, because I need to know under oath on the record why the claim is rejected so I can defend our claim. And the day before the deposition, I got an email that says, you know what, we've reviewed your paperwork, we're going to accept your claim, you know, we'll withdraw the rejection, can you dismiss the lawsuit? That happens often. And so if you walk away from anything out of this webinar, it's all good stuff. And Stefanie and Michelle have great information to convey. You don't respond to a rejected claim as quickly as possible and keep an eye on the deadlines, you will be forever barred.
Okay. Thanks, Scott. Michelle, this one's for you. Is it necessary to follow estate claims to ensure payment, or do courts generally manage the process and creditors get what they get?
Yeah, we monitor our files. Once a claim is filed, we make sure we get our timestamp copy back from the court. If we do not, then we'll call the court to find out why, and then proceed with that. Then once the time frame is over in regards to, it was mentioned earlier, when the claims, we want to find out what's in that estate. We'll contact the attorney if they don't respond. If there's no attorney, we'll contact the fiduciary. We also call the courts for updates, so we check their dockets in order to find out what's in the estate. Basically, we're trying to find out, is there money in that estate to pay the claim. We also will order an inventory if one's been filed from the court, or any accountings, which gives us the assets. And if there's a partial accounting, it'll tell us what is in the estate, what's been paid out. The courts, if they haven't filed an inventory, some courts follow that. They'll send a citation out to the attorney saying, hey, it's been 90 days, you haven't filed your inventory, or a year, it hasn't been, you haven't filed an accounting. So some courts do follow that. Not all will follow the estate, but we continue to follow up just to see what's happening with that. Also too, if an estate's insolvent, which was mentioned earlier, so if we find out the estate's insolvent, and we possibly might get a pro rata payment, which was mentioned earlier, that we might get a partial payment from that estate. So we monitor for that reason too. If there are assets and we might get paid in full, it might be partial, or there might be assets that have liens or something where there's not enough. So it could be a full insolvency. Then at that point, sometimes the attorneys want to ask us to release our claim. Well, if the estate's insolvent and can't pay your claim, we're not going to just release it, because they can file a full insolvency, which then releases the claim, but it's still within the court. So if assets are found down the road, then you would still have your claim, and you could possibly receive a pro rata payment or a payment in full at that time. Most of the time, the attorneys, they don't want to do a full insolvency, so that gives you an opportunity to possibly maybe settle it. If there's just enough to pay, just depends. So yeah, so we do follow it. We do have ways that we use our system to do that. So it's always good to follow what's happening with your claim, just to stay on top of it.
Great, thanks. And you know, we talked a little bit about the individual states and jurisdictional rules and rule changes that occur over time, but you know, we're all kind of faced in the consumer finance environment right now with the CFPB's new Regulation F, which was introduced and goes into effect here on November 30th. Stefanie, has Reg F introduced any significant changes to the collection process related to probate and decedents?
Yeah, it has. So mark your calendars. November 30th, this goes into effect. So what the CFPB did was expand the definition of consumer, a covered consumer, under Reg F. And so now it also includes a deceased person. within the regulations coverage. So what does that mean for you? That means that debt collectors will now be required to provide validation information to the estate representative when it's trying to collect from the decedent's estate. So under the regulation, the guidance that we provided or been provided is that a person this is going to cover anyone who's authorized to act on behalf of the estate. So the executor, the administrator, personal representative, the terms sort of vary by state, but they're now going to be included in this protection. So make sure that you are providing validation information and including that for your deceased accounts.
Great, thanks. Any other comments on that, Michelle? No.
No, I know that on our end, what Stefanie mentioned, that we can't send out letters in regards to the estate of, so we have to actually have a person to send a letter to. So that we're interested in how that's going to work. They're doing things to try and protect the families, and sometimes if you put someone's name on a letter and send it to them, they're not too happy about it. So that's what we're gonna have to change to, and to see how it works.
Yeah, made it a little more difficult, huh?
Yeah.
Great. Well, thanks for the feedback. So just kind of moving into some more audience participation questions that we're taking on here. Scott, I'm going to direct this one to you. Can we file a claim of unsecured debt owed by an heir from the estate?
So if I understand the question properly, an heir owes money to the creditor, and they're going to be an heir of an estate. You know, what are your rights vis-a-vis that heir's debt and the estate? You cannot file a claim into the estate for the debt of an heir of the estate. All right. However, their inheritance is an asset, and typically, if you have a judgment, then you can execute on their inheritance through basically attaching their inheritance. But you have to have a judgment. But generally, you know, if you have a delinquent debt owed you by somebody, and you know that their father passed away and they're going to inherit money, you don't have a direct way to get to that money other than getting a judgment and then attaching their inheritance. And there's a legal process in every state we can attach their inheritance.
Got it. Great. Thank you.
I will add one more thing, and I'm sorry.
Sure.
I have seen it where someone will say, "Can you please just pay my debt out of the estate?" And if they want to agree to that voluntarily, and you can get something in writing to that effect, then you can get that. Then you can get it paid, but you can't file a formal claim.
Good point. Good point. To the panel in general, is the estate process and probate process something that exists really within the continental U.S., or does it extend to the U.S. territories, Puerto Rico, Guam, so on? For anyone
Michelle, you could probably comment. I know that you get claims filed outside the continental U.S., correct?
We do on some. It's not, I mean, it's a little difficult to do it, but we've done it. In Puerto Rico, it's hard because it's more Spanish, and so, but we have done that, and we have communicated and talked to people out of the country in regards to it. Sometimes they're fiduciaries that have left the country that are handling estates, and we're dealing with them out of the country.
Got it. Thank you. Next one, Scott, is it in a creditor's best interest to require a next of kin to refinance a mortgage?
The creditor's best interest is to get paid. I think that's at least that's the business that we're in here, and I think that's the business most people who are on the webinar. Their business is to get paid and not take a loss. If the best way to get paid is to get the property refinanced, through the next of kin, then that's in their best interest. But what I would say is, if they're going to refinance with your institution, your bank, your credit union, obviously you're going to have to make a brand new underwriting decision. And if the question is, should we have an heir refinance even though it's not a great underwriting risk, my answer would be no. I wouldn't do that. Now, if they're going to refinance with a different institution, as long as you're paid, you're paid. So It's not necessarily, I don't know if it's going to depend on a case-by-case basis. I think that there are a lot of our clients that I know that have departments set aside, especially the bigger banks, where they have people deal specifically with that, with loan assumptions, loan refinances. That listen, often it's a spouse. They're living in a house. It's their house. They want to keep living there. They want to take it over. As long as they have the wherewithal, I absolutely have them refinance it. And I think again, your bank or will have a way to do that. But to say it's in your best interest is to get paid, and whatever. Well, then you have public relations interests, and so I'm not suggesting that we don't have branding issues and we don't have considerations that are outside the financial spectrum. But those come with a cost sometimes. And again, I would just reemphasize that they're often the best people to pay the loan off, and they care about the house. They want to stay in the house. They'll do what they can to raise the money, and so that is the easiest often. As long as the easiest also equals getting you paid, that's what I would do.
Okay, great, thank you. Stefanie, if cases of this one's technical. In cases of no estate or admin, assets transferred by intestate succession, what do you do if those successors happen to be young minors?
Oh, that's a great question. So in that case, a guardianship would need to be filed with the court, and that would be filed with the local court because typically in most, or if not all states, a minor, anyone under 18, is not going to be allowed to take an inheritance to receive those assets outright. So therefore, a guardianship proceeding would need to be filed if there was no estate. In my past previous career as an estate planning attorney, I would create these, we called them children's trusts. And so within a trust, you would set aside assets for a child. But in this case, there would be no estate. So therefore, the guardianship would need to be filed. A guardian would be appointed for the minor child, and then would provide for that child's living expenses until they reach the age of majority and then are able to take those assets.
Got it, great, thank you very much. Another question related to kind of the estate location process. So should a bank not know where a borrower died and there's no obituary, what do you suggest about pursuing an estate if one can be located? So we'll make that two parts. Michelle, to you, how about those situations where we just, we're not sure where the person died?
Yeah, well, we can first start with their domicile address of the documents for what they applied for the loan for. We have ordered death certificates, usually with the health department. They'll have that, and you have to just pay for those. Sometimes they're $30, just depends. And then on the death certificate, it'll give you all the information. It'll give their domicile. It'll have possibly where they passed. It'll have like an informant, a contact person. So there are times that we will search in different counties, different states. It's not always just the same place. I mean, they could pass in one place but have their property in another, and that's where the estate would open. So yeah, the death certificate at that would be the best, and then obviously looking at the contract and for that address and go from there. And you can also do skip tracing. You can look them up on certain sites to see what addresses were listed and then try and search for an estate and all the different ones that are there.
Great, excellent. And then Stefanie, assuming we're not successful in that effort, right? How about pursuing an estate or forcing an estate?
I'm sorry, just to repeat the question, you kind of broke up there, Dave.
Yeah,
so is this the question that?
So what? Yeah, if we're not successful in locating an open estate, right? One hasn't been proactively established. Thoughts on how to determine whether you want to force open an estate and make that business decision?
Oh, well, force opening an estate, well, you're gonna have to look at the costs involved. It can be really costly. I've actually have a situation here in Indiana where I've got a claim filed with an estate that was forced open by a different creditor, and we're working with the personal representative in that estate to get paid. But I think you would have to balance as a business decision. One would be how much the estate would be even worth. Are there assets there? Do you know if there's real estate, vehicles, how much your claim is worth, and then again balancing out how much it's going to cost to force open the estate. There's going to be court costs, attorney's fees. So in the case that I'm dealing with, the creditor then has to pay the personal representative's fees. They'll essentially come out of the top of the estate, but there's also additional fees involved. So again, that's a cost balance analysis, but you can definitely force open an estate if one's not filed, and you'd be looking at, the jurisdiction of where your decedent passed away, where the real estate is. That's where your venue, the state and county, would be decided.
So I'd like to add to that. There are definitely times when you would want to force open an estate. And for example, let's say you have a $300,000 piece of real estate and no one's doing anything and you have a claim period coming up, it's something you'd want to do. I can also tell you that we've had clients who are secured creditors when nobody is acting to sell the home. No one's living in it, no one cares about it. And as a secured creditor especially, it may be more cost effective and more efficient to open an estate and then, as the estate, hire a realtor to be able to get into the house, clean it up, and put it into sale condition, and it will be more cost effective, and you'll get a higher return out of that by selling it that way versus an auction from a sheriff where no one can come in and see it. So again, there's I'm going to be very specific on the facts, but we have had more than one time, or many times, where a client says, we have a mortgage, no one's living in the house, we need to get in there and clean it up. If we open an estate, and let's say Scott Weltman becomes a fiduciary, I would then be authorized to hire a realtor. I would then be authorized to go hire some companies to go in and clean it up, paint it, get stuff done. You will get a bigger return on that investment from them being able to sell it to an arm's length sale than to a foreclosure sale. So there are strategies to opening estates that are more than just following your plan.
Got it. Great. Thanks, everybody. And the audience continues to push solid questions here. I've got a really interesting one. Whoever wants to take this one, right? What happens if a customer is murdered and the collateral becomes an exhibit of the part of the crime scene? Do we file a proof of claim and wait?
So I can, well, yes, we file a proof of claim and we wait. Yes, and that, I think for those that have dealt with stuff, you probably dealt with this, often the vehicle, which is part of the crime scene, gets taken by the police, and that vehicle is not released until the criminal case is over with and all the appeals are over. And you're out of luck in getting your collateral. But you definitely file your claim no matter what.
Okay.
Yeah, in the case of a vehicle, we'd have to file a motion of an interested party to protect our interest in that vehicle within the criminal matter. And we've had many of these. Scott's nodding. They're usually pretty interesting fact patterns. But yeah, just to try to get back that vehicle. So we work with the prosecutor's office and the sheriff's department to get the vehicle back. I will say I did have a deceased, a murder case actually, where the vehicle was in the victim's garage, and so we had to work with the victim's family. It was really sensitive, obviously horrible fact pattern, but we were able to successfully work with the victim's family to get the vehicle back. So yeah, that's something we can definitely handle.
Okay, great, thank you. So I see we're up against the hour. Really great questions and conversation today so far. Please note that we want to be respectful of your time. So if we were unable to get to your question today, which I know there were some that we couldn't, we'll reach out to you after the meeting to follow up, and we may address a lot of these in a follow-up webinar. More to come on that. I want to thank the panel and thank you all for attending today's Weltman webinar. We hope you found this presentation informative, and as a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you'd like to see. I'd also like to share that we have a complimentary library of about 20 webinars that you and your team can view on demand. The collection of webinars offers information on a variety of topics such as bankruptcy, real estate, the Bank Secrecy Act, to name a few. We'll send you a link to the library in our follow-up email. Thanks again to everyone for attending, and have a great day.
Thank you.
See ya.
Bye, thank you.
Thank you, everybody.